because I don't know the time zones. I don't know the time zones everyone's in, but thanks to the INBLF and to Annabelle for arranging this session, and thanks to all of you for joining. I'm Marty Zoltik. Let's see if the slides will advance. There we go. I'm a technology lawyer. I'm a partner at Rothwell Fig in Washington, D.C. I have a degree in computer science. I've worked as a software engineer before law school, and I've been focused on the legal landscape around software for about the last 30 years. A substantial part of my current practice involves advising clients on the IP, privacy, data protection, and governance issues around artificial intelligence. You know, the use of AI, data collection, model training, and deployment, broad range of applications and industries and fields. My co-presenter is Magali Fay, and she can introduce herself as well.
Hello, everybody. I'm Maggie. You can all call me Maggie because I know it's a little bit more easy given the French name. I'm a tech lawyer and a data protection lawyer for more than 15 years now. I founded my own law firm, independent law firm, A Contrario, here in Belgium in Ghent. We work around because we work for a lot of startups and scale-ups on the one hand, so we really come close to those items with regard to AI in very innovative settings where the legislation is just lagging behind. And on the other side, we're also now, because of a couple of memoranda I wrote on Schrems 2 and how to deal with that also by using AI and technology. We also write a lot of legislation for the Belgian government. We did that a lot with COVID, but now also with regard to the digital agenda of the EU that we have to then implement in national legislation. And it's a pleasure to be here, and thank you for the opportunity.
Okay, so we have a lot of material. It's a pretty ambitious agenda. We have an hour. We're going to try and leave a little bit of time for some questions and discussion. So I think I'm going to just jump right in. We'll spend a little bit of time on AI, ML technology. I'll do the US, Maggie will do the EU, and then we'll give you some of our observations and predictions. In terms of AI, ML technology, just to set the stage, there are lots of differing views on the definition of AI. The one that I like to use in the work that I'm doing is from the OECD. And this is also the definition that is used by NIST in its risk management framework. And it's also consistent with and aligns very well with the EU AI Act, which Maggie's going to talk about. And just to pay attention to it, an AI system is an engineered or machine-based system that can, for a given set of objectives, generate outputs such as predictions, recommendations, or decisions influencing real or virtual environments. And as we know, these AI systems are designed to operate with varying levels of autonomy. So that's the sort of way I think about what AI is. And today, as we all know, we have this sort of hockey stick-like growth in both core AI, like machine learning and generative AI, and also applied AI, where we're talking about using AI in searching, in natural language processing, in bots, vision, IoT, communications, and so on. So, the tech is speeding along, and the legislation and the regulations, at least in the US, are lagging behind. And, I guess when we did this before, had some predictions about when we might see some legislation at the federal level, but with what's going on, yesterday morning when I was thinking about it was different than yesterday evening when I was thinking about it, because it seems like things have come to a halt for the moment with our government. So let me jump into the U.S. legislative and regulatory landscape. So at the federal level, currently we have no comprehensive federal legislation to govern the use of AI. So is it coming is really the question everyone's asking. And there are lots and lots of initiatives and activity in Congress, at the White House, and a lot of government agencies, which I'll talk about, that are addressing AI. Right before, it was a couple of months ago, before the last session ended on the last day, I went to the Hill to attend a session, and it sort of started off with talking about the bright, shiny object, AI, and how all these initiatives, every senator, congressman, they all are, sort of focused on it and want to be the one to propose the legislation that's going to be the one that's going to get traction. But in the meantime, we have a lot of initiatives and not a lot of, I guess I'll say follow through. We have a lot of focus, but we'll see what happens. And we also have some laws already in place that are very applicable, and we'll tick through those as well. Most sort of recent activity, the Biden-Harris administration, and this was announced in July, got these voluntary commitments from the leading AI companies. Seemed like more of a press event than anything, but it did get a lot of attention. Amazon, there's a list of companies here, all the major AI players were part of it, and they committed voluntarily to ensure that their products were safe before they introduced them to the public, make security a priority, and try and earn the public's trust. I mean, it's great. It's a great commitment. It's voluntary, and I'm not sure, when push comes to shove, how the follow-through is going to be, but at least it shows that there's focus at the highest levels, on this issue, and they're getting the attention of the companies that are, the ones that are playing in this field. And we'll talk about the risks associated with using AI technology, potential biases, sort of not knowing what kind of decisions are being made based on these AI applications. In June, so just prior to that, Senator Schumer launched what he called the Safe Innovation Framework. And this also got a lot of attention and seemed like a very ambitious proposal. SAFE stands for security, and that has to do with safeguarding, national security with AI, and using AI to provide security from an economic standpoint for our workers, accountability, support deployment of responsible systems, foundations, and that really has to do with making sure that the AI systems that are out there align with our democratic values, and then explain, which has to do with more transparency and explainability about the systems that are being used. The way that Senator Schumer proposed to do this, which I thought was interesting actually, was to have these AI insight forums. So a series of these where they bring in stakeholders and experts on AI to give input to the senators about legislation, regulation, what they should be thinking about, how you do the balance, right? So they had one in September, a couple weeks ago, September 13th. 60 senators attended, which was great. Big attendance. Major CEOs from the major tech companies were there. Elon Musk, I think, probably got the most attention because of some of his comments. But it just sort of shows again what the focus is. What I thought was also interesting and I think unrealistic is what Schumer said about the timing. We're not going to set an artificial deadline. It has to be done by this date, but I'll give you this, it's not going to be days or weeks, but it's not going to be years. Months would be the proper timeline. And I just don't think that that's a realistic time frame for getting any kind of federal AI legislation that's comprehensive through. Just a day around exactly the same time, there was a bill that was introduced called the National AI Commission Act, from some congressmen, representatives. Commission's goal: review the U.S. current approach to AI regulation, make recommendations, and so on. The thing I like about this is that the commission, so they want to establish a separate commission within the government that would regulate AI. Thing I like about it is that it's the proposal is bipartisan. They're going to make the group up of legislators and members from industry and society, 3 Democrats, 3 Republicans, and then from the House and the Senate, and then an additional 8 members chosen by the president from bipartisan lists submitted by those groups. So you may end up getting a really good initial group to evaluate these issues. I also thought the timeline was more realistic. They're talking about reports once the commission starts, 6 months out, 12 months out, and 24 months out. So, which to me seems a little more realistic, that a couple of years, 2 to 3 years, when we might have some federal legislation, if ever. I say if ever because I remember, 5 or 10 years ago, when we were talking about privacy, data protection, and GDPR was coming up in the EU, and we were talking about, is there going to be a federal data privacy law? And we don't have that. So this may be a similar situation. The Office of Science and Technology Policy at the White House in October rolled out the blueprint for an AI Bill of Rights. This all is sort of directed to these principles to protect the public from the harms associated with potential harms associated with using AI technology. And so the sort of principles: safe and effective systems, protect the American public from harm, algorithmic discrimination protections. Now, really what that is getting to is, the use of automated decision-making based on AI to approve a loan, or to give a job offer, or to assess insurance. So those kinds of things are part of this blueprint Bill of Rights. Data privacy, so making sure that your data, your data is being used, how it's being used, and so on. Notice and explanation, and human alternatives, meaning you can opt out and have a human decide whether to hire you or give you insurance or credit card, as opposed to an automated system based on AI. In March of 2020, National AI Initiative Act. And so this national was setting up, establishing the National Artificial Intelligence Advisory Committee. This was intended to advise the U.S. government, federal agencies, and so on AI issues, and ensure that the U.S. has continued leadership in AI research and development. And this actually became law in January of 2021. And the actual committee launched in April of 2022. And so tasked with advising the president and the National AI Initiative Office on topics related to national AI initiatives. So this could prove to be very important for our federal government and our standing in the world in connection with AI R&D. National Institute of Standards and Technology. So NIST, to me anyway, is one of the most important government agencies around technology in general, but particularly around AI. And they have made huge effort to provide guidance, best practices to the public, to companies around AI governance. And in January of 2023, they issued the Artificial Intelligence Risk Management Framework, the RMF. It's a voluntary program framework. It's non-sector specific. It's use case agnostic. So we use, when we're helping clients look at how they're using AI and whether they have the right procedures in place, for AI governance, to make sure they know what the AI is doing, they know whether it's safe, they're complying with all the these are voluntary, but they're using best practices, right? So that if for some reason they were subject to an investigation by the FTC or they had other issues, that they're following best practices in the work that they're doing. In the interest of time, we'll begin to the framework. There are a couple of parts to it, but it essentially, in my view, provides a really great roadmap for working with companies and clients.
We knew this was going to happen, didn't we?
Well, yeah, actually, it's 2 minutes early. So, for those of you that are not in the United States, we got a note about an hour ago that there was going to be a test of the public emergency broadcasting system at 2:20. So I apologize for that. And so when generative AI was, I think, one of the or the OpenAI's release of ChatGPT, which sort of brought front and center generative AI technology, that really brought to the forefront in government anyway, and with companies, but in government, the need to look at some possible regulation. And so in June of 2023, NIST formed a public working group on generative AI to sort of, dial more specifically from their RMF to deal with GAI issues. Other government agencies are focused on AI and making pledges to uphold our core principles of fairness, equality, justice, and so on. This is the FTC, which I'll talk about more in a minute, DOJ, EEOC, and CFTB. So this was in April, kind of a public joint statement that they were going to, I guess I'll say, observe and try and determine whether companies that are using AI applications that are within their purview would not be using systems that would discriminate or would have any potential bias. And I don't know the level of sophistication around AI and machine learning, but this comes up because these AI and ML systems only know how to do things based on how they're trained. And the reason we have all this AI ML technology now that is usable is because we, right now, in this time, compared to the last 20 years, have more accumulated data that can be used for training. And we have the processing power like we've never had before. So they've been able to use all this data to train these AI systems. The problem is that it's all in the training data. So if there is a bias or some type of discrimination that took place that's part of this training data, then the AI model that you train, that you're going to now use to make decisions, is going to continue with that bias and that discrimination. So that's sort of the, what's sort of going on underneath and causing the concern. Food and Drug Administration as well issued a marketing submission recommendation. This has to do with using AI ML enabled device software functions. So, software in medical devices that uses artificial intelligence. And obviously there could be a concern about that depending on what the medical device is. So I mentioned the FTC. So the FTC has probably been the most, out front in terms of looking at these AI systems and companies' use of AI. So in April of 2021, they sort of announced the laws that they could utilize to exercise their authority in connection with AI systems. That is for unfair or deceptive trade practices under Section 5 of the FTC Act, with respect to automated decision making, and I've talked about that before. Denying people employment, housing credit, and so on. That's the FCRA, and then the Equal Credit Opportunity Act as well, dealing with biased algorithms in connection with credit discrimination and so on. The FTC has blog posts that they put out, which I think is really interesting, about sort of warnings, if you will. Keep your AI claims in check. This is having to deal. This was the time when generative AI, OpenAI, ChatGPT started happening. You start seeing synthetic media and other things like that. So the FTC is putting out in a blog post, when you talk about AI and advertising, the FTC may be wondering, are you exaggerating what your product can do? Are you promising that your product does something better than the non-AI product? Are you aware of the risks, and so on? And then in July, they kind of put their money where their mouth is. In July of 2023, initiated an investigation of OpenAI. And the civil investigative demand that they put out was incredibly detailed. There were 49 detailed interrogatories and 17 document requests. So that investigation is ongoing. It'll be interesting to see how that plays out. I just want to briefly mention, in June of 2023, no Section 230 immunity for AI Act. So this was a proposed legislation that was put forward that would provide an AI carve out for Section 230. So the idea is, if you use generative AI, you won't get the immunity that an interactive computer service would otherwise get for the content that is provided through their interactive computer service. If you use generative AI, this is intending for there to be a carve out. But that's just, many of these things are just sort of sitting, and perhaps the Congress has higher priority things to deal with at the moment, but at some point these presumably will be dealt with. The other thing I just wanted.
Oh, Larry asked a question in the chat that I just wanted to bring up. So he's asked, is there some reason why traditional remedies for discrimination, consumer fraud, etc., would not be adequate where AI systems are amplifying those practices?
Well, I think that's really like an incredibly important question that everyone is sort of evaluating, including, for example, the FTC. The question really is, how regulated does the area need to be? And if it needs to be I think it does need to be regulated to some extent. Do you want to set up a separate commission, for example, within the U.S. government to deal with AI? And I think part of the issue is, sure, some of these laws that we already have on the books and agencies we have could deal with it, but it's so different and so complicated to some extent that you may need to have real subject matter experts and sort of new legislation put forward that could effectively deal with what it is that is going on. And I think part of it too is oversight. Like for privacy, you have requirements for companies to do data protection impact assessments so that we can see whether they're using best practices and being careful about personal information. It would be kind of the same thing for AI. We don't have anything that requires companies using AI to subject themselves to a risk assessment to see how they're using the AI system, what kind of training data they're using, to be able to assess discrimination and bias and things like that. So I think that's sort of part of it's a little bit of a different technology that it's unclear whether the current laws are really going to be effective to deal with. I'll talk more about that in a minute. Just to mention, Copyright Office is dealing with generative AI issues and works being created solely by AI, currently not copyrightable. You'll see the slides. There's they've come up with some guidance as to how to deal with works containing material generated by AI, which basically is requiring that the author disclose what part of the work was created by AI and what part they did. Patent Office also dealing with the issue. Currently, you need to have a human inventor. If the invention was solely made by AI, you're not going to get patent protection for it. So in terms of the existing laws, there are lawsuits that were filed in the summer, and there are lots of different theories. This all is around generative AI, and there are lots of different legal theories that were put forth: copyright infringement, DMCA, trademark infringement, unfair competition, deceptive trade practices, breach of contract, and so on. This really is simply around copyrighted, trademark, license, personal information content that these companies use in their data sets to train AI models, right? And then generate output. And how do, do they have a legal right to do that? And so I think there's a lot of work that needs to be done to figure out what the right legal theories are to be able to deal with, and whether there's a violation at all, but to be able to deal with generative AI. And then I'm going to stop in a minute and turn it over to Maggie just so we have time for questions. But U.S. states, so moving away from the federal level, no U.S. state has enacted any comprehensive AI legislation, but there's a lot of legislation, both enacted laws and also in process, that deal with AI systems. And when I say deal with AI systems or regulate the use of AI, again, talking about automated decision-making and profiling, hiring, mental health services, credit, GAI, and so on. The comprehensive privacy legislation that has been enacted in 4 states now, I think a few more, like California and so on, those would be usable, if you will, to deal with the use of, for example, personal information as part of training an AI model, or as part of making automated decision making. And then introduced in many states, there are bills or proposed legislation dealing with the use, for example, of automated decision making, and a lot of it has to do simply with disclosure. Our system uses automated decision making, and here's how we use it. We use it to determine whether or not you're going to get qualify for a mortgage, and then the ability of consumers to be able to opt out of that. And you'll see there's a whole bunch more states too that have all different kinds of proposed legislation. And these are all included in the slides. And then I guess lastly, generative AI, is generative AI being used, as part of advertising? Is it real or is it fake? The idea is that certain states are going to have legislation that's going to require an advertiser, for example, to disclose that what you see was created using generative AI. And New York has introduced a law. They call it synthetic media, but it's essentially generative AI, that if you use it and don't disclose, you're going to have a problem. So with that, and I apologize for going fast, but there was sort of a lot to cover. I'll turn it over to Maggie to talk about Europe.
Thank you, Marty. Yes, well, as you can imagine, from the European level, it's a bit another story, because we kind of are in the middle of having a legal framework. And I just want to point out, because I'm a big supporter of the GDPR, But I always have a caveat with that is I really like it when because it's the trifecta of legal, ethical obligations that also need their translation into technical safeguards. But what I don't like about it is that too many authorities interpret it and apply it in a very strict and almost in a way that privacy and data protection becomes an absolute right. And then we see really a shift towards a legislation that becomes very much impractical and that actually has a lot of criticism about it. And I don't think it was designed in that way. And I don't think also with the AI, it's designed in a way for too strict interpretation. But, and it leads, we always start from the spirit of this legislation, and I'm going to walk you through a little bit of that in order to really understand from where we in Europe we came from. But that doesn't mean that I don't have a couple of criticisms on the current legal framework or the text that is proposed. So how did we came to our text is, well, we had a first high-level expert group, and they really worked around ethical principles, the ethic guidelines on trustworthy AI, and they should have been, and they said, well, the AI system or trustworthy AI should be lawful, and it should respect the applicable laws and the regulation. It should be ethical, respecting ethical principles and value, and it should be robust from a technical perspective, but also taking into account being secure and safe and taking into account the social environment. But once again, you see the trifecta of legal, ethical, and technical principles. And from this guide, they came up with 7 key requirements. They said, well, there should still be human agency, human oversight. It should be technical, robust, and safe. Those AI systems should respect privacy and have a data governance model. They should be transparent. They should strive to be explainable and traceable. They should be diverse, non-discriminatory, and fair. With the purpose of avoiding unfair bias in AI systems, which of course could lead to a very big problem. And it should benefit for societal and environmental well-being. So it should be AI for good, of course, and not AI for bad. And they should be accountability, which is also, once again, one of the main criteria or pillars of, for example, our data protection legislation. And they said, well, humans should be able to assess algorithms and the data used for them and the design process. And so from those ethic guidelines, the European Commission came up with a white paper. You made a blueprint. We came up with a white paper, but once again, you see some of the same principles coming forward. But the main building blocks of that white paper was then really having a policy framework, is really creating the right incentives to accelerate adoption and solutions based on AI to really attract people that are skilled and actually train people in order to use AI and not only work for big enterprises, but also including small enterprises. And they really wanted to do this because, of course, it's much more in our DNA to start from, of course, a regulatory framework. And they wanted to create an ecosystem of trust that through compliance of EU rules and legislations, that citizens should really have confidence in using AI applications. And then at that time foster innovation, further innovation through AI and when using AI. And from that white paper, then on, if I can have the next slide, we came with the Artificial Intelligence Act. And so I want to give you a quick overview because it's still a proposal. Where are we today? So the first proposal was published in 2021. It built further on the ethics guidelines and the white paper. As I already said, it is really about that creating comprehensive regulatory framework, but really untrustworthy AI. So with, as you have seen, both texts where it came from was really stressed on ethical principles, and for the moment is being discussed within the European Parliament, and they hope, but nothing is for sure also there, that a final text should be adopted at the end of 2023, where then we should have our AI Act in play. And then, so as I already said, it's built a lot like the GDPR. It's very risk-based. GDPR is also risk-based, as Marty already mentioned. And you have the data protection impact assessment, the very risk-based analysis if you start with, for example, innovative technology. And so we see that they didn't want to reinvent the wheel, but really took a copy-paste. They also, when you have a view on the sanction, it's very similar. They also work with national supervisory authorities, and they will also have an European Artificial Intelligence Board. There, with the national supervisory authorities, for example, the Netherlands have already stated that their data protection authority is also going to be their national supervisory authority with regard to AI, which I think is very good when they combine that, because otherwise you will have different authorities looking at from a different perspective at the same issue, and we already know in Europe that that can lead to different decisions, which of course does not create certainty. You will also have some data breach notifications, a really big issue on transparency. Also, they really take into consideration the different new parties and actors, the provider of the AI system, the importer. But I think that's I think everybody can understand that there are different players when we talk about AI, and they also talk about this obligatory European AI board and an AI office. And then they go further with the different types of AI systems. It really starts from this risk-based approach, where you already see, they say you have AI systems with a minimal or no risk. You have other AI systems with a limited risk. You have the high-risk AI systems who can create an adverse impact on people's safety or their fundamental rights. And then you have a number of prohibited AI practices, where they say those types of AI practices would be an unacceptable risk, definitely at this time, for people's safety, livelihoods, and rights. And if we then see that on a more, for the next slide, so you see when there is no risk or minimal risk, actually, then they, for example, like spam filters or something, those ones are approved and they can be freely used throughout Europe. Then you have the other AI systems with a limited risk when they really interact with the user, but they really want to make sure that the user can make an informed decision. Very much with regard to transparency and things we have known now through our GDPR. So there's also going to be a transparency obligation when you're an AI system with limited risk, in order to ensure that people know really what they going to use, and if they don't want to use it, that they can step back. I see there a really coherence with GDPR, because I don't see if you bring such a system in the market and you have to comply with the transparency obligation of the GDPR, how you would not be able to comply with this transparency obligation. But then we go a step higher and we come to the high risk AI systems, where you see credit scoring, exam scoring, law enforcement AI that is used in law enforcement, operations of critical infrastructure, biometric identification, really seen as definitely AI system that could create a high risk on health, safety, and fundamental rights. And there we start with really having a conformity assessment that needs to be done, record keeping, having technical documentation, doing data governance with regard to the data flows, making sure that whenever the algorithm is creating accurate results, so going away from bias is robust enough and secure enough, and that there is explainability, transparency, and that sort. Which, of course, in some AI systems, like black box AI systems, you can have, of course, quite a difficult task in complying with all those obligations. And then we go to the systems that are deemed unacceptable risk and should therefore be banned. We see for the most typical examples are social scoring that is, for example, used by a government, like we have, or the Chinese example, biometric in identification in public, real-time biometric identification, and a sort of manipulation of the free will, definitely with regard to certain populations or certain groups that are more vulnerable to be manipulated as such. And if we then look at the text, just on how they are really defined, if I can have the next slide, you see that I think I already explained B, C, and D. And B is when they really exploit the vulnerability of a person, of a specific group. So they think about age, mental disability, or physical disabilities, that it definitely should not be based on that. But the problem I have, and I think a lot of the criticism is, of course, if you read the definition of a system that deploys subliminal techniques beyond a person's consciousness or purposely manipulative or deceptive techniques. And if we go to the next slide, you see really the entire definition. But actually, it has to have an effect, distort a person or a group's behavior. But the big criticism on this one is that it is really broadly defined. And actually, with a little bit of creativity, you can put a number of, which I think are not really highly risk AI practices that we already use today, can be put under this sort of definition. And that, of course, would have a detrimental effect towards innovation and AI practices. So we are really lobbying for this definition to be otherwise formulated or really be narrowed down, so that it would not create a broad interpretation and lead to the prohibition of already used AI practices, and that it would not put a ban on innovation. So that's a big critique on this really broad definition. The next slides I think we can skip because it really goes to the social scoring and the manipulation of the vulnerable groups. And the real-time biometric identification. And then we got a new chapter also because, of course, ChatGPT also appeared with us and the generative AI. So there were more stringent transparency obligations put into the legislation. You have to disclose the content that was generated by AI and is not generated as by humans. You have to train and design your models to prevent generation of illegal content. That's a very important one. And for example, if you use ChatGPT in the beginning and you use it now, you see that sometimes a lot of the content is no longer displayed. We believe that it's actually, they're already applying this sort of, in Europe, this sort of obligation already into their systems. They also say you have to publish information on the use of training data that was protected under copyright law. We see that of course falls very difficult with OpenAI and the other generative AI systems, because there is not yet clarity on the whole copyright issues. And of course, they're afraid that if by giving transparency, they actually could be punished for it. So that's still really two different angles that are colliding for the moment. And AI foundation models should provide all necessary information for downstream providers to be able to comply with their obligations under the AI Act. And then just if we can go. So I think the criticism I already dealt with, it's very broad definition. I think also with regard that if we apply once again this regulation too stringent and not in its spirit, where we see that in the beginning, because there are no guidelines, we had the same thing with GDPR. In the beginning, there were no guidelines, and everybody was actually applying the text by the literal meaning of the text, which actually, if we think about the whole marketing, people had sent emails, can I still send you marketing emails? And if you didn't reply, and people lost part of their business. I think we will see probably, and I hope we can actually go away from that, the same reaction on that. And so I really hope that we don't take too much of a stringent position, but that we take ourselves the time in Europe to practice with this AI Act, and by experience create those guidelines as such. So that's part of the criticism. Yeah, I think also there's lack of clarity about biometric systems and facial recognition. Also with regard to the high risk applications, there's no clear delineation, so there could be a backdoor. So that's still up for I think discussion, and up of course for interpretation. I just want to touch very shortly on AI and IP rights. I think they're the next couple of next slides, because I want to leave some time for questions too. So with regard to copyright, actually the summary is very easy on, well, not easy, but there is, when it's purely AI generated output, it is not protectable under copyright law, because AI cannot be an author. If it's, if we can go to the next slides, I'm sorry. Why did I have to instruct me like? But if it's AI assisted output, the Commission came up with a sort of 4-step test, where they said it could be potentially protectable insofar you comply with the 4-step test. So first of all, the output must be a production in the literally scientific or artistic domain. Then the step 2 is the output must be the result of a human intellectual effort. So really with regard to copyright, you have it, and when there is originality and it has a form. And with regard to the originality, they say in the conception phase, AI should not play a role. It should be only play a role, and can play a dominant role in the execution phase. The redaction phase should still be a creative choice of a human. And then with regard to the expression, it means that the result should be the result as conceived and predicted by a human. And we see that most of the time it's really between step 3 and step 4 that that actually a lot of the systems today are not meeting those requirements and are failing the test as such. Just that, you know, they thought about really also creating a new sui generis right, and also creating a new legal personality for AI, because with regard to copyright, our civil legislation is not adequate for it. But there was really an open letter addressed by a number of AI scholars, legal scholars, people working around AI, that says that the technology today was not as far and sufficient enough to already create that legal personality, that we still needed also the legal framework before we can go to that we also not can create a sort of new sui generis, new right as such. So that it's too early for that, and that we first have to work from trustworthy ethical principle onwards, that technology still has to take more form in what is AI and the created works, and then the situation should be reassessed at an appropriate time. I think that's a little bit an overview from the European perspective. I apologize, I also ran through this, but I really wanted to give you that overview and leave some more minutes for questions. Thank you.
Yeah, thanks.
Thanks to both of you. That's fantastic. Really appreciate it. I'm sure lots of people have lots of questions, but we'll start and just see what people wanna know. And you're welcome to just unmute yourself and ask.
No questions?
So, Marty, this is Arnie Lutzker. Your comment on the status in the U.S. Reminded me a lot of work that actually I and others were doing during the era of the development of the internet, leading to, in the copyright area, the DMCA, and there are a range of other activities. I first started working in that probably in the early 90s, and it took the better decade to address these issues. And I like your sense. I mean, I think your prediction that months is totally unrealistic. Years are clearly going to be involved. It's such a complicated area, but perhaps the model that we used in the DMCA, there were white papers, blue papers, green papers. There were many agencies, many of the same agencies involved in AI. And I'd just like to get your sense of whether the handling of the DMCA is a predictive model for, and of course that was sort of regulation of the internet, which was sort of prior to AI, sort of the big new thing that happened in our lifetime. But sort of get your sense of whether that model and approach is potentially a guidepost for legislative and administrative and public action.
As I said before, one of the sort of models that I'm considering maybe the way it's going to end up going is what this country has done with respect to data privacy. And if you look at that, following from what Europe did with the GDPR, you had the states being much more active and being able to, put legislation through to deal with data privacy issues, like, which started with California with the CCPA and now is sort of still populating all across the country because the federal government was unable to, for whatever those considerations and reasons are, unable to pass any kind of comprehensive federal data privacy legislation. My expectation, even if the DMCA is a good sort of roadmap, guidepost to use, and it took a long time to do it, I guess my expectation is that we probably won't see any kind of comprehensive federal AI legislation, just because of all of the different proposals that are being made and the different directions that all of the Congress and agencies in the government seem to be heading in dealing with the AI issues. I think you're going to get lots of frameworks like you see from NIST, and you're going to get lots of companies following those frameworks. But, actually so you have a balance between innovation and regulation, right? And how do you sort of strike that balance? And to be honest with you, my thought, if there is going to be some type of federal legislation, would be to establish a commission, a separate commission within the federal government to deal with AI issues. Because I don't see any agency currently that really is equipped to handle the kinds of issues that will likely come up, or be able to address them at the pace that the issues are coming up. Like we saw with OpenAI. I mean, I haven't looked at statistics lately on ChatGPT, but they were getting millions of users within months. So you really, if you don't have a dedicated agency to deal with those types of issues, and you don't have requirements on the companies to undergo things like risk assessments on a regular basis, I just don't see how it works. So that's sort of my thinking on it. And we might be talking about this in 10 years.
Marty, this is Larry Friedman. Just to follow up on that, I'm thinking about law firms and law firms implementing AI for various reasons, whether it's to do work or, principally to do work. And the ability of bar associations and state courts to regulate around this? And lawyers are, notoriously, not in all cases, but notoriously behind the curve on technology. So do you have any thoughts on like law firm implementations and best practices and what law firms should be thinking about?
Yeah, I mean, there's sort of two sides to it, right? So we get mail and calls every single day about AI tools that we can use to be more efficient in litigation and all the things that we do. On the one hand, on the other hand, we have things like ChatGPT that lawyers use to write letters and briefs and things like that. So I think the law firm has to be very active in terms of setting up policies that provide best practices for how a law firm can use AI tools, right? When it's appropriate, when it's not appropriate. And then I would hope that the AI tools that the vendors are promoting for us to be able to operate within our practice are, sort of, I guess, vetted in a way that is not going to cause us to run afoul of, bar rules and, other issues. But I would expect that you'll see, I don't know, call it regulation, but I assume you're going to see guidance from the bar associations on the use of AI in law firm practice. I haven't really, focused on a lot on that other than the policies that we're trying to put in place regarding the use of AI in our law firm.
Yeah, I'll just tell you one quick story. I don't know if it's that common, but in the court where I practice, a judge issued a standing order saying that if the law firm used ChatGPT or Bing AI or another similar service, that they needed to certify that none of the search parameters, none of the prompts included confidential business or privileged information. The concern being that information is then part of the training materials in the next iteration of the large language model. I'm not sure that the judge actually thought through the fact that when you make just a standard Google search, that information is also recorded and goes into the algorithms. It's not that different, but I just thought that was an interesting piece of judicial regulation right there.
We were talking about that actually recently because we were talking about our policy. Well, I know you shouldn't put client confidential information or privileged information into, ChatGPT. Well, of course you shouldn't. You shouldn't put it into Google either, right? I mean,
exactly right.
Yeah. So it's become more upfront and in everybody's face because of ChatGPT. But a lot of the sort of principles that we probably followed before would equally apply. So Arnie, I don't know how long you want to go. We're happy to stick around and answer some more questions if there are any.
I think.
Well,
oh no,
yeah,
sorry.
go ahead.
Go ahead. No, go ahead, Arnie.
No, I think so. Certainly, there may be a couple of questions in chat, and maybe go for another 5-10 minutes. That would be good. I do want to sort of do one or two wrap up points as well.
Arnie, do you want to say those just before other people? Because I know people will have to hop off, and if you want to just add those points before people, just to make sure everybody hears it.
I mean, there are two things. First, my hope is that at our annual Black Tie meeting in Prague, which will be November 16th to 19th, that we can continue this kind of conversation. I look forward very much to sort of organizing the working group members that are there in Prague, and I would encourage anybody that has not yet sort of thought of attending the Prague event, look up on our events page on the IMDLF website, Prague, and certainly consider joining the group. We've got roughly 70 members and guests so far already attending, and it'll be a
Great.
fabulous event. And in addition, and this is sort of for further internal conversations among members, the whole idea of what role can we play as the network to take advantage of all these various developments that are occurring in the AI area, both in terms of developing business opportunities, sharing information, and the like. I think this will be part of the working group, but people that have any level of interest in this, I'd really encourage them to join the working group. Contact Annabelle for any more details about that. But I think this has been just a fabulous introduction, Marty and Maggie. And Maggie, I want to explore. You have an open invite to come to Prague as well. We can explore that if you're interested.
Very much, thank you. I don't know if you had a second point.
No, that's
If I
fine.
can-
You can, yes.
I just wanted to jump on the previous round of question and discussion, because we've seen that also a lot, and I think all with regard to using AI systems and also with regards to data privacy. And I always believe that if you are a practice in data protection, AI and technology, you should lead by example. And so I got really frustrated when because there is new also that tendency that we as law firms, we also have to be innovative and really use AI, but I don't think that you always have to use it, because we blocked a system that we said, well, sorry, with regards to your training model, we have no any safeguards with regard to our data we're going to upload and everything. So that just, I'm sorry, is not good enough. And then from our bar association came, there's this lawyer who's want to be punk and innovative, and he goes like, yeah, you have to start using TikTok. And I was like, I'm sorry, but how can you say that for messages with regards to confidential things? So I think we should lead by example. I think we should definitely look at the possibilities in our work where there are really good solutions with regards to NLP and document-based AI algorithms. But I think we should always, and I think we should lead by example and be the first ones to be very critical and say, okay, how do you do that? Because I think when clients come in and they ask me and they say, well, we have to do this whole DPIA and everything, what are you doing? Then it makes a very difficult case if you then have to say, oh, but we are using this system or this system from India or whatever, or this. And so we are very meticulous on that. And I think it's good to be innovative, but don't do it at the cost of your own business and your own message and your own business model that you're practicing or preaching to clients.
Gotta practice what you preach. All right, well, thank you, everybody. And Arnie, I'll get back to you about Prague and the working group and all that. Sounds great.
Thanks to
That's
everybody who
great.
joined. Thank you so much. And yes, to Magali and to Marty, this was fantastic. And like I said, it'll go up on the website, and this was brilliant. And if anybody has any questions and needs me to connect anybody after the webinar, feel free to send
Ask
me.
me about meds, hun, for your ADHD.
Oh, I don't think that was for us.
Thank you.
Thanks, everybody.
Thanks.
Speak soon.
All right.
Thanks, everyone.
Bye-bye.
Bye.